application, my lord. And discovery of a document. Documents, my lord. Of 1987. Whatever this Dulal Pal, father of this petitioner, died in custody, my lord. He was arrested in connection with the foreigner's case. The final order passed by the Sonipur FT. And my lord, thereafter, thereafter he died, and there was agitations and other things. Ultimately, dead body was taken over by the family members that I have annexed. And the government had also, the Honorable Chief Minister then had also assured, my lord, that the government would file the review, my lord, for review of the order of this court, judgment of this court. But they didn't file. Ultimately, son has come, my lord. A lot of kindly see the new document, my lord, annexure 5 and 6, page 25 to 32. In fact, my lord, his grandfather was already proceeded under the Foreigners Act long back in 1987. In 1987, his grandfather, my lord, was proceeded, and he was found to be have entered India with permission, my lord, with necessary permit.
Just a minute, Mr. Sharma. So Mr. Sharma, what do you want to tell us today?
My lord,
Review should be hard.
yes.
Okay. Mr. Payal?
Earlier occasion, the matter was, there was a question arise.
Yes. The question, we have framed the question last time.
Yes,
The question, therefore, which our consideration is whether a review petition can prefer a dissenting person to declare. Obviously, because he cannot be now, so long his his parents or grandparents are, that if one of them is happens to be a foreigner, obviously he can't be declared to be Indian. Therefore, he has a right. Therefore, we'll admit this. Hear it on a date.
Yes.
That point, my lord. My lord,
You want that to be decided also?
My lord, your lordship may decide, because
Okay.
otherwise
No,
it will remain, my lord.
Very well.
Only point, my lord, my submission was that what my lord, there is no, I have searched so far, my lord, but I didn't found any, my lord, similar case earlier.
Correct.
My lord,
Because this is a very, this is a unique jurisprudence. Yes.
My prayer was that, my lord, because the writ petition was disposed of,
Yes.
and my lord, the
Mr. Pine, why don't you follow the principle of substitution?
my lord, that's
If
why
the right
that
to
is
sue
why, my
or
lord.
to be sued survives.
Yes, my lord. That's why, my lord, it is
Substitution
the
is
review has
permissible.
been filed directly, my lord. Only
So
my
if substitution is
my
permissible.
prayer was that, my lord, they may file a leave petition before this honorable court to substitute and allow them to file a review, my lord.
No, writ is already disposed. How can you file a writ petition?
No, my lord, for a leave petition, let them to allow them to file a review petition along with substitution. Otherwise, my lord, this review petition has been directly filed.
Okay, you want that formality to be complete.
Yes, my lord. Then, my lord, your lordship, then there may not be any, my lord, but
Mr. Sharma,
Yes.
you have been shown the indicated do whatever you want, file an application or application for substitution, whatever. We will proceed. We'll hear it. We fix a date. Today may not be possible. In the meantime, whatever additional affidavit or application you want to file, you file.
Then the problem will be not,
My-
what my understanding.
In
Mr.
fact, my lord, the
Pine
family is
suggests-
penniless.
Mr.
Living in
Sharma,
a family.
Mr.
Other
Sharma.
died in jail.
Mr.
Correct.
Sharma, we
Nothing was
understand.
given.
Mr. Pine is suggesting that you complete the formality of filing IA, one for substitution and one for leave. To
In
prepare
this
a-
case or the earlier case, my lord?
In this case.
In this case, because
That's what he
There
said.
are-
earlier case is disposed of. You can't.
That's why the review is there.
Correct. So in review, Paying feels that it will be more appropriate if you file also an application for substitution that you are the so-and-so.
Yes.
They may be allowed to substitute it and file a review accordingly that they have a right to challenge it.
This review will remain.
We
Here only I
are
find-
not saying anything on this. So in the meantime, parties may file necessary application oblique affidavit. We will see that. We are
Because
not saying anything.
that-
When we pass the
that
final
is
order, we will
government-
clarify everything.
Government should also be concerned about the justice to the family.
Whatever, therefore, we'll ask both parties
Yes.
to file their necessary affidavit oblique application. Then you come across. You also file whatever you want to file. No, not mere oral observation or objection.
I am not objecting, my lord.
No,
Only
no,
my-
objection or any observation you want to make. If it can be
No,
put in
certainly
written
not.
form, that will be also good,
Yes,
because they will also know what is the stand of the government.
yes,
Huh?
yes, madam.
Because otherwise, the stand of the government not put in writing, they wouldn't know. They will never know what is the stand. Isn't it? Huh?
Okay.
So let the government also file their affidavit. Huh? In the meantime. Huh?
Yes.
Okay. We will repeat that because perhaps notice wasn't issued, Mr. Sharma. No, notice was issued earlier.
Yes.
The record have been called for.
Yes.
What about the record FT case number 37? Then, but we have to call the original record also.
That record, my lord, 87. Yes.
Record of the, my lord, application.
The record, my lord, is of
Take the decision.
page 26.
Okay, okay, very well. Okay. वो तो है भाई उन्हें डिले हो जाता है
It is foreigners case number, my lord, 451 of 1987. Page 25.
List the matter of the harm Mr. R.P. Sharma and Senior Counsel assisted by Mr. Miss S.V. Chetri and Counsel for the review petitioner also Mr. Paying for the state. Baki some naam likhna. Yes. FT number 9 Sonitpur at Dhoka Ghazi may be reminded to send the records forthwith. Just to send a record relating to FT 9 case number 223/2017 forthwith. Matter will is rather weak.
And my lord, that original record also.
That is what we have called. No, this is original.
No, no. The-
Original means is to FT 9.
1987.
What
What is it?
1987 you are talking about?
Yes. Page 28.
There were two proceedings or what?
My lord.
There were two proceedings or what?
Against the grandfather, my lord, he was clear that he came with permission of the reference made by the SP.
Which one? Which record you want us to requisition?
My lord, page 25.
Rajendra Paul.
Yeah, Rajan Pal is grandfather, yes.
Okay. 28.
And forensic case number 451 of 1987.
This can be called after we hear the matter, and if we find that this is a necessary material, then we'll call for it. But
Because-
regulation calling for the records will be the order which is under challenge in this proceeding. This is another proceeding. And you
Yes,
intend to
another proceeding, my lord.
take the support of that proceeding.
Yes.
So that we'll have to see in course of the hearing, whether it is relevant or not. If
Unless-
relevant, yes,
yes.
then it will be called.
Unless it was already relied in the earlier that proceeding.
No, my lord.
Then so you are relying this as a
It was, my lord, it was
therefore this
discovered-
is your is a new piece of evidence, information.
It was, my lord, only after I, as an ex-member parliament, I delved into the matter,
Okay.
personally went to the.
We have
specialist
understood
advisor.
you, it is additional information,
Yes.
evidence,
Yes.
that we will see that. That can be. In the meantime, parties may, the respondents, state respondents may file their by affidavit in response. I am not saying objection.
Yes.
Affidavit in response. Petitioner also may file their additional affidavit oblique application if needed.
First, two regular appeal and two reference. So in the aspect of item 1(8), my lord, I need some more time for preparation, my lord. Can it be taken, my case, can it be taken on my lord 17?
You are telling that this one,
Yes, my lord.
Tends
Additional
to-
additional hearing.
additional, this is a criminal matters.
Yes, ma'am.
Item number
8.
Item number 8 is, no, it is with death sentence.
Yes, my lord. Two regular appeal and two reference alongside the two appeal.
Okay.
So if the other side do, then they will to develop. My case, my lord, is 8. I may be allowed till my lord 17, my lord. On 17, I will do my case.
Today is what day?
Today is Thursday, next Thursday, my lord.
Today is
Today is my lord 10. On 17, I will do.
17 means next week.
Next day.
Okay, because see,
If the other side in other item, they can, my lord, they can continue. But my case,
normally we don't like to adjourn this criminal
I
matter.
am
See
not
how
going
many.
for adjournment because the regular appeal is there. They can do their case, my lord. Only in my case, my lord, I will argue it on Thursday.
Okay, then we will not pass any order. It
No,
will
no,
remain
no,
here.
this order is required. my lord.
Okay,
Then
okay, we'll keep in mind. Yes,
oblige.
yes.
My village, I beg to mention for listing your lordship, motion matter your lordship,
Motion matter of what?
but foreign your lordship,
Huh?
FT your lordship.
So it will be listed. It will be once you file, it will come on the list. Why you have to mention? Tell us. I don't understand.
On last 7/11/2022 file.
Huh?
7/11/22. I have
7/11/22. This 7/11.
Yes.
Today is what day?
lordship.
Today is what day?
And your lordship.
Then why it will come up? What is the urgency? If you have purchased a ticket, it will become, don't worry, it will come up. Don't mention. Flood all the bit papers. It will come up. In spite of your filing and the registry is not taking a matter, is not coming up. That's another. But yesterday, therefore, yesterday was a holiday. 7 is what day? 7 is Monday. Then 8 was a holiday. So you can't expect the registry to function like a. It'll come up. Don't worry.
Lordship.
It'll come up. Come up. Yes.
May I please, your lordship? So I beg to mention one matter for listing the admission column, lordship.
What is the urgency?
Urgency is that lordship, he is a very old aged person, lordship, and he is currently suffering from lordship different illness, lordship.
So
Lordship,
is it a criminal matter?
no, lordship.
Then?
The matter is the lordship, the petitioner challenge in order passed by the FT, lordship.
So it will come up.
Lordship, where he has not been declared foreigner, lordship, but he want to examine to witness, lordship. And he served notice also, but they did not come, lordship. That's why, lordship.
So the matter is pending with the tribunal. What?
When your lordship has a call for the LCR, lordship. That's
So it will
But-
come up. We'll see that. What is the problem?
since lordship, he is a ill, lordship. That's
So?
why,
How does it matter?
he's a very old aged person, lordship.
Huh? It
He's
will
a
come up. Don't worry. Yes, next.
Bless me.
Please, your lordship, my lord, I beg to mention for listing of a review petition for admission, my lord.
Review. Have you filed?
Yes, my lord.
When did you file?
It's filed on, my lord, 17/6/22, my lord.
76.
17/6.
Review against whose order?
Judge, my lord, foreigner's case order, my lord.
Oh,
It was,
review.
my lord.
Huh?
I
Review.
don't
part
remember
of-
the name of the judges.
Mr. You please don't mention like that. Don't come half back,
it was on-
half information. No, whenever you make a mention before this court, you must have all the information in your fingertip. Otherwise, don't make guessworks and do that.
Well,
First, find out who is the judge, because if it is a different, then it has to go to the Honorable Chief Justice for administrative purpose.
my lord, the
When
judges
you
have
make a
retired, my lord.
mention there, huh?
The judges have retired.
So you mention there,
Court number 1.
code number 1, because see, we can't take it up. You should understand these basic procedures. See, we can't take it up for ourselves. It required the administrative approval of the Honorable Chief Justice. If it happens, if the same bench had passed order, we would have taken it up. Okay.
My lord, another writ petition, my lord. For
Yes.
motion.
What is that?
Writ petition for motion, foreigners case, my lord.
When did you file?
My lord, on 17/8/22
So what happened then? It has not come up at all.
came up once, my lord.
Then it will come up. Don't worry. It will come up. Don't worry. There are many cases it will come up. Computer will do the necessary. Computer will sorting out, not human beings. Okay, it will come up for your turn. Yes, next.
May I please, your lordship? Lordship, I beg to mention for listing one I, lordship. Lordship,
I for what?
lordship, modification of orders, which was passed on 7/11/22.
Okay, modification of what?
Lordship, it should be SP Darang, but it's reflected as SP Udalguri.
Okay, SP Budalguri.
Yes, my lordship.
Yes,
Lordship, tomorrow, lordship.
not tomorrow, don't. Tomorrow, as if you know this. Registry is all waiting for all this, you only. It'll come up next week.
Next week.
Give some time to the system to adjust. No, don't say tomorrow.
Obliged.
You know, bypass surgery or something immediate. No, you are in ICU or something like that. Give some time to the system to absorb.
Obliged.
If the system says, or because maybe you may have a defect because of which they are not entering also. So we must see that. Okay, it'll come up, don't worry. And that mistake was because of this code or because of you?
Lordship, lordship, code, this code.
Huh?
This code, lordship. This
See-
not this code, code number 4, lordship.
Huh?
Code
When
number
it-
4, code number 4, lordship.
No, I'm not in that. Is it because of the mistake in the typing of your petition or because of the course or?
No, lordship, lordship, a petitioner was detained by the SP Dorang, but a petitioner residing at Udalguri.
So you should have make it very clear when the order was passed. Anyway, it'll come up next week.
Obliged, lordship.
Daily list for motion, item number 1 to 14.
These matters are probably relating to my transfer of matters from one tribunal to another.
Yes, so I
Right.
think, so it is listed today for what purpose? All these matters related to transfer.
Some motion matters are coming, my lord, again and again, and some more matters are.
All matters relating to pair or transfer.
See, correct. So what is to be done today? Is it to be hard or what?
My
What?
lord, in fact, my lord, earlier it was hard by
Ah.
this court.
Then
Then my lord, matter.
the issue is whether there is any reason, whether it is punishable or not. Is there any
Yes, my lord.
decision?
Lordship has also asked us to file an additional affidavit, enclosing the judgment, the pleading of the writ petition.
Ah.
Pleading made in the writ petition by the Moinul Haq case. Moinul Haq case was considered for transfer by the
Yes,
apex court,
yes,
but dismissed here, my lord.
yes.
So, my lord, Lordship has asked us to file an additional affidavit.
Have you done
enclosing-
that? Have you done that?
My lord, yes, we have filed additional affidavit in item 3, Lordship will file, in my case.
Jongdu Ali.
Yes, my lord. Unless he was declared foreigner by the tribunal at Jorhat by an ex-parte decision.
Then
And my lord, he filed a petition for petition challenging that ex-parte order, as well as as IA was also filed, claim for transfer of the case to his home district, my lord, Kukrajar. And these all cases are for consideration of transfer, whether considered can be.
so there is a decision of the Honorable Supreme Court
Yes, my lord.
in Moinul Haq,
Yes, my lord.
where it was allowed.
Yes, my lord.
Page 140.
Yes, my lord. Lordship will find in my additional affidavit in page 140.
In
Sorry?
their,
In my affidavit, my lord.
in their additional affidavit, page 140 is the order of the apex court.
Okay, 140.
Yes, my lord.
Yes.
My lord.
This was,
Uh,
my lord,
Leave granted, having gone through the pleadings in.
This was passed in 2019, January,
Yes.
29 January
Yes, my
2019.
lord.
particularly in that case, madam.
Yes, correct. Moinul Haq. Yes, then what about the Moinul Haq case?
Moinul Haq case was, my lord.
Yes,
Thereafter, my lord, this judgment, after passing of this judgment also,
Yes.
this honorable court has taken view of this order, my lord,
okay.
and passed the order, details order.
What is that? What is it?
It
Have
is-
you compiled that?
That is, my lord.
You have your
Yes, that I have submitted 2780 of 2019.
2780. Sariful Islam.
Yes. There were, my lord, numbers of cases but they have sentenced, they have asked for transfer of cases, my lord. There are more than, I think, 19 just.
In Sariful Islam, was
has been
this
discussed.
question considered?
Yes, this was.
Moin, let us see what is the decision of this court.
I don't-
What is the view of this court in about this Supreme Court decision?
My lord, may I kindly see, it is from my lord, is, my lord,
Yes.
my lord, your lordship may kindly see,
Itu kilo just tweet.
para 11, my lord,
Just give me a minute. Just.
para 11, from para 11 onwards, man. Paragraph 11.
So anyway, we'll hear that. We'll whatever to be decided, we'll decide. We have to decide. We have to pass some order today. this way or that way. So you argue your case then.
My lord,
My lord, my
My lord.
point is that, my lord,
Yes.
if the matter has been but settled by this member court in fact, by a coordinate bench of this.
We'll see that. Let them argue also. We are not saying anything now. What we have to pass some order, we'll pass an order. Whether we go by that earlier cognate bench decision that we are bound by this, therefore we will dismiss. But in any event, we have to pass some order this way or that way. So we'll pass the order. So you argue your case.
my lord. My lord, here in the case of Shariful Islam.
How long you are going to take?
My lord, 20 minutes, 20 to 25 minutes.
How many cases are there?
My lord, 60. 40.
Because we have to do ration. When there is a scarcity, when there is a scarcity of any petrol, then there is a rationing of petrol. 10 liter for car, 5 liter for scooter, 20 liter for trucks. So we'll ration it and finish it up because we cannot on and on, we cannot hear. So we'll ration the time. How many of you did there? How many cases today listed?
14.
All the lawyers are present? 14 cases and Mr. Sikdar, you are appearing how many cases?
My lord, one case, my lord.
Which case?
My lord, item 3.
3.
Yes, my lord.
Item 3. Karim, Jonglu,
Jonglu, my lord.
Sikdar. And who is in item number 1? Mr. Islam. P. Rahman. How many cases you have got? 8. So you are custodian of 8 cases. 1 into 8. 1 into 8, 8 cases. Now Sikdar is 1, 9. And how many cases? 14. That means 5 cases more. Yes, how about you, Mr.?
18.
Huh?
8, my lord.
Item number?
8.
Mr. Hussain, you are, Mr. Ahmed, you are ready with that?
Yes.
Huh?
Yes.
Okay. What about then? Others? One, number 2, who is number 2? Hyder Ali, who is appearing? Huh? You are appearing Hyder Ali? Yes, Salim, huh? Then number 3, Sikdar, then number 4, Rahman,
14,
5, number Rahman, 6, Mr. Sheikh, then 7, yeah, Mr. Suleiman, J.M. Suleiman, number 8, then number 9, Rahman, 10, Rahman, 10, 11, 12, Rahman, 14,
14, I, my lord.
Mr.
S.H. Mahmood, my lord.
Huh?
S.H. Mahmood.
H.S. Muhammad, okay. 14. Okay. How long you are going to take and how all of you are going to take? Tell us.
I will take only 5 to 10 minutes.
So, Rahman, I am calculating, keeping, Rahman, 5 minutes. Mr. Sikdar.
My lord, I may require some more time, my lord.
Tell us.
25 minutes.
25 minutes. Then, Mr. How long you are going to take?
5 minutes.
Huh?
5 minutes.
5 minutes. Huh? Mr. You are Mr.
S. Alim, my lord. Item 2.
Item number?
2.
Okay. A Salim.
Yes, ma'am.
A Salim. 5 minutes. Anybody else? Is Mr.
6, ma'am.
Mahmood?
10 minutes.
Huh?
Sheikh, ma'am.
10 minutes.
Yes.
10 minutes. Anybody else left? Huh?
7. I am at 10 minutes. 5 minutes.
5 minutes.
10 minutes.
10 minutes. Now how much? Because let us see. 25, 30, 35, 45, 50, 60, 1 hour. 1 hour. Yes.
Item was 14, my lord. I will take 5 minutes. 5 minutes.
5 minutes. Okay, 1 hour. So buying this side is 1 hour. How long you are going to take? 2 hours?
My lord, I may have, I'll have some time, my lord.
Okay. Now, I mean, at least we have some idea how far we will proceed today. Okay, you proceed. Then perhaps we can conclude today in that case. Huh?
My lord.
So you argue, yes, Mr.
My lord, I want to come to my writ petition first, my lord. My lord, WBC number 7309.
7309.
Yes, my lord.
Yes.
My lord, here in this case, my lord, so for the my documents
Oh.
of documents,
Yes,
my documents while relating to claim of my citizenship are all from Kukrajar district, annexer 1 to annexer 13.
page number.
My lord, page 14. My father is voter in 1966. Page 14, my lord. Hyder Ali. Village, my lord, Aibandar, PS Kukrajar district, subdivision Kukrajar. D then are my lord, Gwalpara district. Then my lord, subsequent
Page number.
page 14 of my requisition.
Nineteen 66 voter list.
Yes, my lord.
What the Hyder Ali?
Hyder Ali is my father. Then my lord, 70 voter list in the next annexer 2 at page 16.
No, okay, this is Kokrajhar, no?
Kukrajar.
So what do you want to say?
I want to say that, my lord, all of my documents in support of my claim of citizenship are lying with the district magistrate Kukrajar. My lord, I have also annexed other voter list showing my name also. Annexer 3, 4, 5. Up to
Yes, up to so
Up to-
annexure, so all
up to
this
annexer 13.
annexure 1, 2, annexure
1, 2, 3, 4. Then my lord, up to annexer 13. All these are documents.
1 to 13.
Yes, my lord. All these are voter list of my parents and myself are in the district of Kukrajar. Then my lord, kindly have a look at my lord the notice.
Yes, yes.
My lord, proceeding, my lord, went to sometimes stay in Jorhat district, and the notice was issued, annexer at page 40, my lord. The vernacular is at page 41. His name is written Jonglo Ali, Pita Hyder Ali, Niva Hasora Ita Bhata. Then, my lord, process server report, my lord.
Ita Bhata. Ita
Yes,
Bhata is where?
my lord, in Jorhat district.
Jorhat.
Jorhat.
What is the process server report? What is
Page 42. Vernacular at page 43. Well, process server, my lord, the SI of border submitted report. It is hereby inform you with respect is that for trace out of the person mentioned in the aforesaid notice, namely Jonglo Ali, I visited big industry at Hasora and came to know that said big industry already damaged. On asked the government Gavura, he informed that in present there is no existence of said big industry. Aforesaid person has not been resided at my locality and put signature and signed thereon. As such, notice has not been served. The Malada report, the person mentioned in the aforesaid notice, namely Muhammad Jonglo Ali, son of late Hyder Ali, has not decided at my locality as closed. The Hasara big industry. So, my lord, the process server could not serve notice because the proceeding was not staying there. Then, my lord, the impugned order of ex-parte decision at page 44. My lord, here the judgment, my lord, at page 44, the state is present, OP absent without state as reported in the notice by serving person, OP left the place of abode for unknown destination. As such, it was decided to proceed with the case ex-parte. The witness for the state is examined from the statement of the witnesses and other materials available in the record. It is seen that OP entered into the territory of India illegally after 25th March 1917. The OP failed to produce any proof before the inquiry officer or before the tribunal that he is the Indian citizen or foreigner as defined under section 6A of the Citizenship Amendment Act 1985. Now, my lord, I want to go to the, my lord, record of the case. My lord. Here, my lord, it is said that the proceeding could not prove his case before the inquiry officer as well as the tribunal. My lord, what was the materials before the inquiry officer? That point is important, my lord. Inquiry report, my lord. My lord, record we have seen.
Yes, yes.
My lord, in page 8 of the record goes to show that admittedly his statement was recorded. The proceeding claimed that he is a resident of Aibandar, Gusaigaon.
Why are you reading from where?
My lord, in the record, I have seen the record, my lord.
Okay, in the case record. Yes, in the case record, yes.
Yes, my lord. Page 8, my lord.
Yes, statement of
Jonglo Ali dated 2010-2003, saying that he is a resident of Aibandar, Gusaigaon, Kukrajar, but no signature. My lord, other witnesses, no signature.
how can there be statement signature when the police record?
Signature is not in the, my lord, record I have seen, my lord. The statement recorded, no signature.
Okay, anyway.
My question is that whether that inquiry report can be a valid inquiry reports, my lord, as per the Muslim Mandal judgment.
So the statement which you given
My lord,
before the, it says that
I am resident of Aibandar, Gusaigaon, Kukrajar.
where is it?
And it is
Okay.
My
Right.
point is that, my lord, his statement may record by the police, but there is nothing in the record that he was intimated that an investigation relating to his citizenship is going on by the border police. That part is totally missing, my lord.
What is missing?
My lord, he is to be intimated. He is to be asked his documents relating to citizenship. But records does not say so, that he was intimated about the inquiry, about his status as a citizenship. That part is missing. And his signature after recording statement was not taken, my lord. So in my lord, my submission is that in view of the full bench decision in Muslim Mandal case, paragraph 97, the inquiry report is not a proper inquiry. It's not a fair investigation. So reference is made mechanically, my lord. So reference was made mechanically without giving him an opportunity to demonstrate that he is not foreigner by producing his relevant documents at the investigation stage itself and no signature. So this inquiry report is not a proper inquiry report is not a matter of fair investigation. So his defense at the investigation stage was denied. So it is a illegal reference matter. And when he disclosed that he is a permanent resident, he is an ordinary resident of Kokrajhar, then my lord, the authority, investigating authority of that area ought to have intimated to the district of Kokrajhar to conduct investigation. Then only investigation would have been a fair investigation. That is also not there. My lord, he went there without any documents. My lord, how he can produce his documents, my lord? So the investigation is a mechanical my lord, unfair investigation. So reference is mechanical. So my lord, reference itself. Asadul is to Kopala, essence. Here are the Gita code. Dota like one thing. Put the how open.
Yes, yes, Mr. Sridhar, yes.
My lord, I want to, my lord, lordship is aware about the Muslim Mandal judgment in paragraph 97, my lord. My lord, I want to read the relevant paragraph,
Mhm.
my lord. Paragraph 97,
Yes,
my lord. Paragraph 97, fair investigation and fair trial being the basic, fundamental and human.
then, okay, we have gone through that, yes.
My lord, and here, my lord, there is one line that the proceedings after recording his statement, signature is to be, signature come, whatever. we will
Yes,
obtain.
please.
My lord. My lord.
Fourth line.
Yes, my lord. In the investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given the opportunity to demonstrate that at the investigation, at the stage itself, that he is not a foreigner. In case the person concerned could not be found out in the village where he is resorted to reside, or in the place where the ordinary resides or works for gain, the investigating agency has to record the same in presence of the village elder or the village headman or any respectable person of the locality. Within in turn would ensure visit of the investigating officer to place where such person ordinarily resides or reported to reside or works for gain, and making an effort to find him out for the purpose of giving him opportunity to produce the document, etc. If any, to demonstrate that he is not foreigner. The investigating officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated. After recording his statement, if any, provided makes him available for that purpose. My lord, what has prevented the authority in not taking signature in the statement? That is my point, my lord. Then, my lord, to ensure proper investigation, also having regard to indicate an instrument in the nation, once investigation relating to the nationality status of a person start, he must inform the investigation agency in writing about the stance of resident, etc. My lord, so this is my submission based on this paragraph. Then paragraph 19, the reference by the referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass detailed orders according to his restriction. An order agreeing with the investigation would suffice. The referral authority also while making the reference shall produce all materials collected during investigation before the tribunal, as the tribunal is required primacy to satisfy itself about the existence of the main ground before issuing notice. My lord, here grounds, my lord, as a material, my lord, nothing except some statement, but without signature and no other things, my lord. So, my lord, here, my lord, the proceeding was not given any time, any opportunity to produce his relevant documents. And when he claimed to be a ordinary resident Praja, the investigating authority, to ensure a fair investigation, matter ought to have been remanded to the border police of Praja to carry out investigation, where his documents relating to his citizenship are available, my lord. In each case, there are two sets of facts, my lord. One fact, facts leading to allegation. The other fact is to rebut the allegation. So my facts, my lord, to rebut the allegations are lying with the district administration at Kukrajar. So only fair investigation is possible in my locality, in my home district. That was not done. The police, whatever statement is recorded, given to the tribunal mechanically. My lord. That is my submission. My lord. So reference prima facie is illegal, and based on illegal reference, the cognizance of the case is also illegal. My lord. Then, my lord, I am to my lord on my additional affidavit enclose the record of Supreme Court's, my lord. My lord, if there is one additional affidavit filed by the petitioner enclosing the
Page
petition, my lord.
number.
My lord, lordship will find the grounds taken in the writ petition.
Page.
Page 134, my lord. My lord, writ petition start from 122 and ground part in the writ petition at page 134, my lord. The grounds for transfer was and is as because all the records he is to rely upon are issued by local and district level authorities of Karimganj district. Further, his very old and ailing parents has to adduce their evidences, and for them it will be very difficult to take journey of about 360 kilometers from the remotest part of Karimganj to Guwahati. It will be very expensive and unbearable for the petitioner. Again, the headmaster who issued the school certificate, the panchayat certificate issued by the secretary of panchayat, the electoral rolls from 1951 to till date are issued by the district electoral registration officer Karimganj. The land documents issued by the deputy commissioner revenue Karimganj. The land deeds issued and registered with the local sub registrar at Karimganj. Family identity cards, ration cards issued by the food and civil supplies inspector. My lord, here, my lord, it is the contention of the Moinul Haq case is that his all records or registration of records are lying with the district magistrate Karimganj, and all the witnesses to prove his documents are of that area, my lord. Whether it may be a private witness or maybe a government witness. My lord, how they will come, my lord? The government witness never come. My parents are there, his parents were old, and all these facts, my lord, was considered by the Supreme Court, and the same ground was taken in the SLP, my lord. Lordship will find in my SLP, in the SLP of Moinul Haq case, my lord, at page, it starts from page 54. Moinul Haq was also deep voter in his district, my lord, Karimganj. So he also filed a writ petition before High Court, removing his D against his name in the voter list. That part was also in the available records, my lord. Here grounds are, my lord, at page 54 onwards, my lord. Here I want to only refer, my lord, the grounds at page 59, my lord. Ground 15. Because from 1966 till 2011, all electoral rules indicated that the petitioner, along with his parents, is citizen of India, born in India, permanent resident of a set address. The documents like issue certificate, consent certificate, sale deed, land documents, and all other documents.
Page, you are reading page
My
number?
lord, at page 59. There are so many grounds, but I am focusing on the ground number 15. My lord. That all documents relating to his electoral roll, land documents, panchayat, schools, all are lying in the district of Karimganj. The same grounds are taken in the writ petition. So these are considered by the Supreme Court. And pass the order, my lord.
Yes, sir.
My lord, no, my lord, I have some more submission, my lord. My lord, I am also relying on judgment of this honorable court in the case of Asadur Islam. Here also, my lord, transfer was considered,
Yes.
my lord, Asadur Islam, my lord. WBC number 3644/2018. My lord, page 2 of the order. Mr. Mahmood submits
You are referring to which judgment you want to?
my lord, it is decision of this honorable court, my lord, WPC number 3644/2018.
Asadur Islam.
Yes, ma'am. Judgment by Honorable Justice Urup Kumar Goswami and Honorable Justice Amar Pathak.
Three six four four 2018. 3644.
No, may I read it, my lord?
Yes, yes.
My lord. I have to read, my lord, the
Yes.
relevant paragraph. Third paragraph is the relevant, my lord. Mr. Mahmood submits that the petitioner had filed his written statement and had also filed evidence in chief in 3 witnesses, including himself. He submits that the petitioner is a resident of village Patapara in the district of South Salman and Mankasar, and he had gone to Jorhat for his livelihood, where he received the notice of the reference, which resulted in registration of JFP case number so. It is further submitted by him that though the petitioner is ready and willing to face cross-examination at the foreigners tribunal at Jorhat because of financial constraints, the other 2 witnesses are not willing to travel to Jorhat for purpose of cross-examination. He submitted that the burden of proof being upon the petitioner for establishing that he is not a foreigner. If his 2 witnesses do not appear before the tribunal at Jorhat, the petitioner will suffer irreparable loss and injury. He submits that 2 witnesses will, however, appear before the tribunal at Hatsingari if the case is so transferred. Upon hearing the learned counsel appearing for the parties, we deem it appropriate to transfer JFP case number so from the court of learned foreigners tribunal Jorhat to the court of learned foreigners tribunal Hatsingari of South Salmar district, if the case is not yet disposed of. So, my lord, the transfer was considered by another ordinary bench, my lord, by the considering the facts and circumstances and for fair trial. Fair trial cannot be possible because the witness will not go. he has some other difficulty. So my lord, this is my lord, and my lord, I want to make a short submission on the Rule 21 of the Citizenship Rule 2009, my lord. Citizenship Rule 2009, Rule 21, 22, my lord. Yes, my lord, my book is different, but I think rule will not be different, my lord.
Rule,
Citizenship Rule 2009,
rule
Rule
number?
21 and 22. 21 says that when reference is registered,
Jurisdiction of tribunal.
tribunal get the jurisdiction. But my point is that reference should be a valid reference, should not be mechanical reference. If it is mechanical, the tribunal should not take cognizance. He has no jurisdiction. That is my point, my lord. I have already submitted on that, my lord. The reference is not a fair. It's not a, it is a mechanical reference. That is one point, my lord. And the Rule 22, my lord, says that when a person get ordered or a declaration under Section 6A, where he is to register his name, he is to register his name in the district, under the district magistrate where he is an ordinary resident. My lord. This conjoint reading of these two rules says that reference would be a fair if it is investigated in the district where he is ordinary resident. That is my point, my lord. Because the registration is suggested, my lord, this rule says that it should be within the district magistrate where he is an ordinary resident. Rule 22. And my lord, the facts, there are two sets of facts. One facts, my lord, reference, and other set of facts, his documents, the documents registered, voter list, land documents, birth certificate, death certificate, marriage certificates within his home district, my lord. So, my lord, the reference which has been made mechanically, that cannot be facts. So, my lord, the tribunal cannot take cognizance based on an investigation unfairly conducted and reference made on mechanically, my lord.
Okay, we have,
My lord.
yes.
My lord, so far the facts, my lord, I have one judgment. Corona limited person. Corona limited is gracias. I don't know this. My lord, paragraph 27. 11. Mere taking, my lord, mere making a reference mechanically, that cannot be a facts, my lord. Here, this honorable apex court has, my lord, paragraph 27. Jurisdictional facts, my lord. Paragraph 26. Stated simply the fact or facts upon which the jurisdiction of a court, a tribunal, or an authority depends on the can be said to be a judicial fact. If the judicial fact exists, a court or tribunal or authority has jurisdiction to decide other issues. If such fact does not exist, a court, tribunal or authority cannot act. So this is my submission. The tribunal has not have the fact of reference, my lord. The reference fact in reference, a mechanical and false reference, that is not a fact. And my the proceedings defense not being given, my lord, at the investigation stage, the reference is mechanical, my lord. That is my submission, lord.
Yes, we'll just note down the submission of Mr. Sigdar, please. Huh? और मिस्टर सिकदा या सिकदा and counsel for petition also सब नाम लिखना है. The matter relates to transfer of proceeding from the tribunal located in Kokrajhar. Kokrajhar, you have been
My lord, I am
to
from
tribunal to Jorhat.
proceeding is at Jorhat.
Jorhat. While challenging the impugn, why is the impugn order?
My lord,
While
at
challenging
page 44
while challenging
in
the
writ petition.
while challenging the opinion of the learned tribunal, while challenging the opinion dated page 44.
Page 44.
Opinion date opinion date 11/3/2010 parcel learned FT Jorhat in FT case number so page 44. Next paragraph. Before we advert to the detailed facts and submissions advanced by Mr. Sigdar, we'll just briefly refer to the relevant facts in issue. Next paragraph. Next, as per according to Mr. Sigdar, the petitioner Janglu Ali is a permanent resident of.
I bandar.
Why is that? Why is
My
that?
lord, lordship will find in page 4 of the writ petition.
Page?
Page 4 of the writ petition.
Okay, page 4 of the petition.
Resident of village I bandar 2. Bhaudaguri.
Is a permanent resident of village Ali Bandar.
I bandar.
I Bandar.
I bandar.
I Bandar number 2 between bracket I Bandar part 2, comma Bhaura Guri, P.O. Kamal Singh, comma P.S.
Gusaigaon. PS Gusaigaon, district Kokrajhar, BTC.
You are a permanent resident of Kokrajhar?
Yes, my lord.
Okay. Kamal Singh Sanda, P.S. Gosaigaon, district Kokrajhar, BTC, Assam. He, because of his because of financial economic necessity, he had ventured out of his permanent place of residence in Kokrajhar and had obtained a temporary employment in.
My lord, that is Iter.
Page.
My lord, at
Where do we find
that
it?
will be in the notice, my lord. Hasora Itabhata. At page 40, my lord. Page 41, my lord.
He obtained a temporary employment in a brick field located at Hachora Itabhata in
PST of, my lord,
which district?
PST of
Jorhat.
Jorhat, my lord.
District Jorhat district. Full stop. And working was employed with one Maloya Saikia. However,
Yes, ma'am.
However, after the said brick kiln was closed down, he left the place. He left the said place in Jorhat in search of another employment. Full stop. However, unfortunately, the investigating authorities investing under the Foreigners Act, Foreigners Tribunals under the Foreigners Citizenship Act, Citizenship Act inspected, made an inspection the said brick field and made inquiries about the present petitioner and not being find. No. Uska pehle, there was an inquiry was.
Yes, my lord.
Yes. When during his stay, during his stay, an inquiry was initiated by the inquiring authority under the Foreigners Act as regards the citizenship of the petitioner when certain doubts were raised about the citizenship. Accordingly, accordingly, the statement of the petitioner was recorded by the inquiring authority. While making the statement before the authority, the inquiring authority also recorded the fact that the petitioner is otherwise permanent resident of
I Bandar.
2 number Aibhandar, Thana, Gosaigaon, Jila, Kokrajhar, and he had come to the said brick kiln located in Kokrajhar in search of his to earn his livelihood, and he also, however, informed the inquiring authority that his father had cast his vote in 1966. And as such, he is an Indian citizen. However, he is not educated, and he can obtain the necessary.
He has not taken any proof while coming to.
Okay, and he has not brought any documentary proof relating to his citizenship, including
Citizenship while coming to.
to documentary proof of citizenship while coming to Jorhat for earning his livelihood.
And he had half a bighah of land.
He also stated before the inquiry authority that he possesses a land measuring half bigha. What is it? What is it? He also stated before the inquiring authority that he would be able to obtain the necessary documents from his residence within 15 days. Full stop. It appears that the employees of the petitioner in Jorhat also gave the statement stating that the petitioner he hails from Kokrajhar district. Full stop. However, the inquiring authority made a reference to the referral authority. The inquiry authority next. The said on the basis of the said inquiry made, the report was duly submitted to the referral authority, and the referral authority on the basis of the inquiry report made a reference to the tribunal stating that the petitioner is a foreigner, and accordingly the proceeding was initiated against him before the Foreigners Tribunal Jorhat in number 6, na?
My lord.
In JFT 1767/2006
Yes, ma'am.
against the petitioner. Full stop. It has been submitted by Ms. Nextwell. This is the case of the Mr. A. Sigdalana Council for the petitioner. That though inquiry was held while he was in employment in the said brickfield, thereafter, since no further, he was not intimated about the result of any such inquiry, and on closure of the brickfield, he left the said employment in Jorhat. However, in the meantime, during his absence, the proceeding was initiated before the Foreigners Tribunal, and when the notice was sought to be served at the address while he was in employment in a said brickfield located in Jorhat, and since he was not found available in the said place of employment, the tribunal deemed it to have been deemed the notice to have been served upon him, and accordingly proceeded ex parte, as the petitioner could not appear before the tribunal, being unaware of the proceeding initiated before the said tribunal. Full stop. Thus, consequently, the ex parte order dated 10/11/2021 was passed by the Lanet FT in so and so declaring the petitioner to be a foreigner. Next para. This is the order which is being sought to be challenged in this petition. Next para. Mr. Sigda Lanet Council for the petitioner has raised two grounds in challenging this order. Firstly, firstly on the ground, firstly, that the tribunal otherwise could not have acted in the manner it has done. Number two. Secondly, it has been also submitted that number one, the tribunal could not have acted in the manner as there was no proper inquiry nor proper reference, and proper reference and number two, and proper reference, and that the tribunal lacked the jurisdictional facts to act. Next para. Secondly, it has been also otherwise submitted that even if the state desires to proceed against him, they ought to have proceeded before the Foreigners Tribunal Kokrajhar, where he is a permanent resident of which he is a permanent resident, and not in Jorhat, where he was staying there temporarily for earning his livelihood. Full stop. According to it has been submitted that this impugned order dated passed by the Learned Tribunal Jorhat is liable to be set aside, and that the matter be remanded to Foreigners Tribunal Kokrajhar. Kokrajhar. Full stop. Next para. Next para. Coming to the issue of lack of judicial facts for initiating the proceeding before the Foreigners Tribunal located in Jorhat, Mr. Sikdar has submitted that petitioner is indeed the son of one Hyder Ali. You are the son of Hyder Ali?
Hyder Ali.
Hyder Ali, who is a permanent resident of Kokrajhar.
I
Bandar too. And all the documents, including voter list and other connected documents, to show that his father Hyder Ali is an Indian citizen, are to be found under the authority of the district administration of Kokrajhar. In this regard, Mr. Sikdar has drawn attention of this court to voter list of page 14.
My lord, page 14 onwards.
Voter list of 1966, wherein the name of one Hyder Ali is mentioned in respect of 38 number LAC Kokrajhar West within bracket ST ST under 225 Oi Bandar village, comma PO Bhauraguri, comma PS Kokrajhar, comma subdivision Kokrajhar, comma district Gwalpara.
Astral
Gwalpara. Next. The another electoral list of 1970 in respect of the same 70 for whom?
My lord, 70, my lord, of his father, my lord. Father's name is at serial number 71, my lord. Lordship will find in the page 70.
And the voter list of 1970 in respect of the same
Village.
Village and district and legislative assembly constitution relating to his father has also mentioned. In the Learned Council also has drawn attention to Annexure 3, which is a voter list of 1985, wherein the name of his father Hyder Ali, and whatever you know,
My name will come later on.
Later on. Again shown in respect to the same village and the same LAC. So is a voter list of 1989.
89, madam. 89 next.
89.
Annexure 4.
89, where the name of the petitioner appears as a son of Hyder.
Yes, ma'am.
In respect of the same
village.
Same village. 4. Then annexure 5.
Annexure 5.
Annexure, then the petition also has drawn attention to electoral roll of 1993. They're showing the name, he's showing his name as a son of one Hyder in respect to the same village. 97, other voter lists relied upon the 1997, 2009, 2010, 2011,
then
2013,
13 and 14.
14
also.
2014,
Then 2017.
2017,
This one.
117?
Yes, my
Huh.
lord.
In which the name of the petitioner along with his wife and other children are shown, a resident of the same village, Ivando number 2 of the same, under the same LSC. Thus, it has been submitted that all the documents, the name of the petitioner is found recorded in the documents maintained by the district administration of Kokrajhar. Full stop. The fact that the next the fact that the petitioner yeah, that the next one, it has been submitted that apart from that, all other his other relatives are presently staying in Kokrajhar, and as such, all apart from that, all the other witnesses who would establish this claim that he is an Indian citizen are all residents of Kokrajhar, and no one is residing in Jorhat, where he had gone for temporary work. It has been submitted, Mr. Sigda, that normally, under normal circumstances, the petitioner ought to have been proceeded before the Ordinance Tribunal in Kokrajhar and not before the Jorhat, as has been done. He submits that it is not the fact that it is not the case that the authorities were unaware of the fact that he is a permanent resident of Kokrajhar. In fact, during the investigation which was carried out by the inquiring authority, as also revealed by the record, the inquiring authority was fully conscious of the fact that petitioner was a permanent resident of Kokrajhar, as informed by him as well as by other witnesses who are the employees. In fact, during the inquiry also, he had mentioned before the inquiring authority that if he had been given 15 days time to submit the necessary documents, he would be able to do so, as he is a permanent resident of Kokrajhar. But however, no such opportunity was given. Next, Mr. Sigdar accordingly submits that this would indicate that there was lack of proper application of mind by the inquiring authority when the inquiry was made against him. To stop. Even if, according to Mr. Sigdar, even if the inquiring authority had made the report, the referral authority ought to have considered this fact that he is a permanent resident of Kokrajhar and not a Jorhat, and accordingly ought to have made the reference to the competent tribunal located in Jorhat, not in Kokrajhar. In this regard, Mr. Sigdar, relying on the decision of the honorable of this court, of the full bench of this court in Muslim Mondol, has submitted that it was incumbent upon the referral authority to make to apply his mind. तो उसका पहले देखो, इसका पहले देखो. Mr. Sigdar also submits that the inquiry itself also was vitiated for the reason that the same was not done properly, as held by this bench, by the full court of this bench in Muslim Mondol. The fair investigation required that while making the investigation, the investigating officer is supposed to obtain the signature of third impression of the person against whom such investigation initiated after recording his statement. In the present case, it is clear that the petitioner was very much cooperating with the authorities, but however, no such no such signature was obtained from him of him, and any copy given to him, copy to him, full stop. Therefore, it itself indicates that inquiring authority was not conducting inquiry properly. Full stop. Next, be it as it may, even if be it as it may, be it as it may, the referral authority, when the report was submitted to the referral authority ought to have applied his mind properly on the investigation so made, and make the reference only after being fully satisfied that there was proper investigation carried out. In the present case, it appears that the reference was made by the referral authority mechanically. Mr. Sigda submits that it was known to the referral authority based on the inquiry report submitted that the petitioner is a permanent resident of Kokrajhar, not Jorhat. Yet the referral authority decided to make the reference to the foreigners tribunal located in Jorhat. In this regard, Mr. Sigda has drawn attention to para 98 of the Muslim Mandor case, which reads as follows, para 98. Next para. It has been further submitted that once the reference was made to the tribunal ought to have been also satisfied about the investigation as well as the reference made, and thereafter only they being satisfied ought to have proceeded. More so, the tribunal ought to have been satisfied about the judicial facts presented before it, so as to proceed if the tribunal felt that the tribunal lacked the judicial fact, it not ought to have taken up the matter and ought to have referred to the concerned tribunal having judicial facts over the matter. In the present case, it has been submitted, it is very clear from the records that the petitioner is a permanent resident of Kokrajhar and not of Jorhat, and as such, the tribunal, the foreigners tribunal located in Jorhat ought to have referred the matter to the foreigners tribunal at Kokrajhar, or ask the referral authority to refer it to the foreigners tribunal located in Kokrajhar, which, however, having not done, it has been submitted that the same is vitiated. Mr. Sigda, learned counsel for the petitioner, submits that in an earlier case, in a similar case, before this court, in Asadhar Islam versus Union of India, decided by this court in WPC number 3644/18, when a similar situation arose, this court directed transfer of the proceeding from one tribunal to another where the proceedee was a permanent resident of. Permanent resident under to the tribunal where under whose jurisdiction the proceedee happened to be a permanent resident of. Mr. Sigda also relied on a decision of the Honorable Supreme Court rendered in Moinul Haq, wherein the Honorable Supreme Court passed the following order. It has been submitted that similar fact situation arose in the case of the said Moinul Haq. In other words, it was specifically pleaded in Moinul Haq case before Honorable Supreme Court that for transfer of the proceeding from
Kamrup Guwahati to
from Foreigners Tribunal number 2 Kamrup M at Hadiapur to Guwahati to Foreigners Tribunal at Karimganj. In a said case of minor, it was specifically pleaded that the that all the records which the proceeding therein wanted to rely on were issued by local and district authorities of Karimganj district. And he had very ailing parents who were required to adduce evidence in his support, and who could not, and as such could not afford to travel a long distance from Karimganj to Guwahati, which would be very expensive and beyond the financial capacity of the proceeding to do so, arrange, and also the authorities who issued the certificates were located in the said Karimganj district, and the Honorable Supreme Court, taking into consideration the said plea, allowed that transfer the proceeding from Guwahati to Karimganj. Next paragraph. Petitioner submits that the law also contemplates that those who are covered by the protective clause under for registration is for those
My lord,
who can get registered.
my lord, when declaration under section 6, my lord,
Section 6. Why is that?
my lord, rule 2000,
No, there were 2009, but then that section 6A. Let us see that 6A.
yes, my lord.
6A.
My lord.
Those who are declared
My
no
lord,
foreigner, but yes.
Rule 21, my lord, of
Correct.
Citizenship Rule 2009. No, 22, my lord, Rule 22.
No, correct, but declaration, no? The
Yes, my lord,
subsection 6A.
6A.
Foreigners Act. Section 6A, Foreigners Act.
6A of the Citizenship Act.
Sorry, Citizenship Act, yes. 6A. Rules of provided Citizenship Act. 6A. Mr. Sigdar also submits that there is a certain protective clause, beneficial clause in the Citizenship Act 1955 is contained under subsection 6
Yes, my lord.
of subsection 6 of section 6 of 6A of the Citizenship Act 1955, which provides for registration of such person who are otherwise found to be foreigners but eligible to be registered as Indian citizen, but such persons are required to register themselves before the district magistrate of the area within whose jurisdiction such person is ordinarily resident. In the present case, assuming but not admitting that even if that the petitioner is declared to be foreigner within the meaning of subsection 6 of section 6A of the Foreigners Act 1955, he would have been required to register himself before the district magistrate in Kokrajhar, not in Jorhat. Thus, the scheme of the act also would indicate that the foreigners tribunal before whom any suspect is to be proceeded should be the one where the proceedee claims to be ordinarily resident of. In the present case, the petitioner had made a specific claim before the inquiring authority that he is a permanent resident of Kokrajhar, not of Jorhat, which was duly noted by the inquiring authority in the inquiry. Yet they proceeded, they referred the reference was made before the Foreigners Tribunal in Jorhat, and the Jorhat Foreigners Tribunal, without applying his mind, proceeded against the petitioner ex-parte as mentioned above. I think these are basic points you.
Yes, ma'am.
Accordingly, it has been submitted that for some next paragraph. Accordingly, it has been submitted that the impugn order does so pass and FT Jorhat is liable to be set aside and the matter be remanded for fresh reconsideration before the foreigners tribunal, Kokrajhar. That's your case. Yes.
My-
Next day, who is the next? Yes, please argue your case.
My lord, before, my lord, may
No,
I
we're just noting down.
No, my lord,
Yeah.
one thing is there, my lord. The issue here is, my lord, here first of the issue here is, my lord, transfer. And second, there are, my lord, my learned friend has argued lot of issues there in the writ petition. My
No, no,
lord,
no. In
because-
his case, in Sigdar case, mere transfer, see, transfer will arise when we decide. Suppose we do not find fault with the legality of
yes.
the tribunal's order, then the question of transfer doesn't arise.
Then, my lord, I have to argue each and every case separately because.
Yes, yes. In this, you
that
can
way,
argue
my
also.
lord,
Yes, yes. You argue
because
in that.
Then, my lord, I will need some time because.
No, no, no problem. We'll give you time.
I'll-
No, Don't
because
worry.
each
We'll
and
give
every
you.
case, if I will argue,
Absolutely.
my lord, not very.
That is, we have gone through the evidence of Mr. Sigdar also,
Yes.
because that is also required to examine. It is not because here it is a live, it is a only decided case. If it is a matter where the matter is still pending before the tribunal, then yes, whether it should the present tribunal should continue or should be transferred to the another tribunal, that is one issue.
Yes.
But here I think in all these cases, the cases have been decided or some are not decided.
My cases are not.
Just a minute, in that case, Sigdar is your case is a decided one by one tribunal. Is there any other case like similar to Mr. Sigdar where the case has been already decided? You decide, then we'll hear him also, then we'll hear you.
Lordship,
Where is still pending, that is one aspect. Huh?
Lordship.
Then we don't have to go into enter the merit of the case,
Yes.
factual merit of the case. Here, in case of Sigdar and yours, we may have to go into look into the record, whether it. Yes. So here, Sigdar case is number one. He is questioning the very validity of the whether we transfer or not. The very validity of the decision of the tribunal. If we uphold the validity, the question of transfer doesn't arise. Suppose if we uphold his petition, his ground, if we set aside, then it has to be remanded. Where do we remand? Either remand to Kokrajhar or Jorhat. So these are two different issues. Yes. So your case is also decided.
Decided, but in ex-parte manner.
Doesn't matter. Which case is that? Item number?
Item number 2 manner.
Item number 2.
Then, my lord, this matters will be. My lord,
Yes, yes, we'll hear you. We'll give you, yes. We will hear you on merit also. Mr. Pai, we'll hear you on merit also.
My contention is that if it is hard, my lord, I have to go each and every case.
So we
separately.
do that. There are only 5
Because,
cases. We are reading 100 cases. You read also 100 cases sometimes. What to do?
Matters which have been, my lord, already decided, those may be separate.
No, we are doing it. They were segregating it, separating it, but we'll hear. We'll hear.
In this
Yes,
case.
Hyder Ali.
Yes,
Is
my
your
lord.
case Hyder Ali?
Yes, my lord. In this case, what happened, my lord? Earlier, I was decided.
That's
Final,
all.
my lord.
That's all. This is that. One. Yes, what is your case? Tell us.
My lord, in this case, what happened? Earlier, I was declared foreigner, my lord. And challenging the same, a writ petition was preferred before this honorable court. Your lordship will find the earlier order at page 48, my lord. The matter was remanded back. I was directed to appear with my WS before the tribunal, my lord.
Yes, then?
Accordingly, I appeared, but
Hmm.
on that very day, the WS could not be submitted and an adjournment petition was filed, my lord,
Hmm.
which was allowed, subsequently fixing the matter on 6/4. From 6/4 onwards, the matter was, the brief was missing in the court, my lord.
6/4 of
6/4/2017, my lord. The record was missing in the court, my lord.
6/4/2017,
17, my lord,
before the tribunal, huh?
tribunal, my lord. And subsequently, while the record was found, I was intimated by the engaged counsel to appear. I appeared on 3/2, my lord. 3/12, my lord. In the court, a specially prescribed notice was served upon me, my lord. As because in between there is a gap, my lord.
Sorry?
As there was a gap and the record was missing, my lord.
Hmm.
So a specially prescribed notice was served upon me
Hmm.
that your lordship will find at page 54, my lord.
Hmm. Hmm.
Your lordship kindly note the case number, my lord, at the top.
Hmm.
FT SVR 6818. This is the notice, sir.
Hmm.
But if your lordship comes to the impugn order, my lord, at page 60, my lord, the case number is something different, my lord.
Where is the impugn order?
Page 60, my lord.
But then after you received the notice, did you go?
Yes, my lord. I
Where did you
submitted
go?
in the
Where you go, you must appear with written statement on 13/12/2019. Huh?
yes, my lord.
Notice to submit written statement on
13/12.
13/12/2018. What did you do? On 13/12, did you appear?
Yes, my lord.
13/12, notice likely to be issued is received directly from office. Page 56.
Page 56, my lord.
13/12/2018. You did not appear. Received notice received today. No step is taken. Direction.
This is the order sheet of some other record, my lord.
Then when you appeared, what did you do?
I submitted petition in FT SBR 6818.
Where is
my
that
lord.
petition? Where is the copy of the petition? Where is it?
That copy is not available, my
And
lord.
then how do we know?
My lord, kindly come to the
How is the
order.
record? How do we know that you have submitted? But the tribunal was proceeding in some other court, some other file.
The impugn order is passed on the basis of the notice I have referred, my lord. Since it is not a notice in the connected case, so this is not the notice is not properly served, my lord. And without notice, the impugn order is not tenable, my lord. If your lordship comes to page 61.
Just we'll see the record. You had personally appeared before tribunal.
Yes,
isn't
my
it?
lord.
So you must have put some appearance or whatever it is.
I have appeared in FT SBR 68, my lord. Can you see the order sheet, page 58, my lord?
But that notice number may be out of the same proceeding.
For the said anomaly, the impugn order has happened, my lord. I could not submit my documents. So now my only prayer is that a chance may be given to produce my documents regarding the citizenship, my lord.
FT SBR 6818.
Yes, my lord. And the impugn order has been passed in connection with some case number FT 428 2005, my lord.
And when was the first, before the case was lost,
Your lord.
when he challenged it, what was the FT number? 428, the same thing. When he went to this High Court, when
Yes,
he
ma'am.
came, approached the High Court earlier, it is the same FT case number 428. 428 is, this is your case.
The impugn judgment is telling with the earlier order, my lord. But in between the order sheet that I have annexed, my lord, that is the record of some other case, my lord. How they can serve notice in that case to me in a case of 428, my lord.
But you went, whatever it is, you went there.
What is the notice that you have received? Page
Page 54.
The petitioner is a semi-literate person. He is not totally aware about the case number also. On the basis of the instruction of his learned counsel, he appeared. And for the mistake of the counsel, I am suffering, my lord. I have also made the party of the advocate.
It is not that he didn't notice, he received the notice.
maybe there is no, but he case number is not there, but he's aware of this case
Yeah,
because he
yeah.
earlier appeared before High Court.
Yes.
Then it was remanded.
Hmm. And this is the old one, huh?
This is the one earlier. Vishwas said he was not available in demo,
Hmm.
but Vishwas, demo, Vishwas was available.
No, he's a when you receive the, did you receive the notice?
Which one, my lord?
The second notice
Yes, my lord.
you received. Then did you go to the tribunal?
Yes, my lord.
Then what did you say to the tribunal?
I put signature in
Where
some
is that?
papers.
What is in the put some paper? How do you say that? Why did you say that you had appeared in your petition?
These 8 papers, whether submitted or not, I do not know. That is why I made the concerned advocate as party respondent here in my lord.
This is a separate issue. Not a principal case.
So this is an ex-parte case. So what
Yes, ma'am.
is necessary to transfer?
On
Why
last,
it is mixed up with transfer case?
on last occasion, your lordship was supposed to pass a order regarding remand.
Then
At that moment, I placed my prayer that the matter may be remanded back to the home district, my lord.
home district is what?
Borpeta, my lord.
It is by Jorhat.
It is in Jorhat.
But the notice now in demo only.
But you are in demo, you are in demo, you are.
Notice now in demo.
No, my
But you
lord.
are, oh, mister, you are making all kind of, in your petition,
There is no prayer for transfer.
arey, see, don't make our life so complicated by making oral submission.
If the matter is remanded back to Jorhat, again such thing will happen, my lord.
Oh, then, but then you must make an application accordingly. You can't just make oral or submission like that. If you want that remanding is another thing, we'll remand to Jorhat. But you said it should be some, it should be remanded to where?
Borpeta.
Borpeta. Then you have to make an application. You can't just make an oral application like that. You can't take it so lightly, the proceeding. Tell us, otherwise we'll fix another date for this case.
I will file proper application.
File application. We go hard. Huh?
In the meantime, spend 15 minutes.
15 minutes, huh? 15 minutes judicial time. You know how much money
I'm
it
sorry,
costs?
my lord.
Huh?
I'm sorry, my lord.
See, you should be careful. I thought these are clubbed together because that you have not made any application for transfer also. Mr.
Yes,
Alim.
Alim.
Yes, Alim.
Issue of transfer raised from my petition, my lord, not from others, my lord.
We don't know. See, but then you must have a proper pleading to that effect application. Na? Okay, Mr. Alim, submitted, he may be allowed to file additional affidavit oblique application for transfer of the proceeding from FT Jorhat to FT
Borpeta.
Borpeta. He may do so, at least a matter of 2 weeks.
I am obliged, my lord.
And what is your case? Case number here?
Transfer.
Your item number?
1, 4, 5, 9, 10, 11, 12, and 13 years. What is the disposal?
Item number 1.
Item number 1.
Hatem Ali.
Hatem Ali.
In Hatem Ali, is the matter still pending before the tribunal or it has been decided?
Pending, Your Lordship. Only notice has
Pending
been-
before whom?
Only notice has been served.
Pending upon which FT?
Jorhat, Your Lordship.
Jorhat. Where is the notice received by you? Jorhat. Acha, have you called for the records of this? No.
13, not
Not called. And how do you say why from Jorhat to
Morigaon.
Morigaon? Why you want to go to Morigaon? On what ground? Have you mentioned in your petition?
Lordship.
What is it?
Paragraph 15 is there, Your Lordship. Page 8.
That number 1 shows that you are a permanent resident of Morigaon.
Morigaon, Your Lordship. Notice has been served to Morigaon.
Otherwise, you are a permanent resident of?
Morigaon.
Then where is the
Page 15, Your Lordship. Voter list.
where is the matter pending? Jorhat.
Jorhat, Your Lordship.
From Jorhat, they send a notice to Morigaon.
Morigaon. To my permanent resident. Permanent address.
Then how it was proceeded in Jorhat? Do you have any idea? Why from Jorhat? Do you have any idea?
Lordship.
Did you visit Jorhat?
Lordship. Paragraph 3. The
Yes.
petitioner went to Nazira for work and stayed there for some days.
Nazira is in Jorhat district. Huh?
Brickfield.
Soraya.
Shivsagar it is. This
Shivsagar.
Shivsagar. The reference has been made by the Superintendent of Police Shivsagar. The petitioner provided his details to the owner of the brickfield. From that, the reference has been come out. Without investigation, without going through the documents.
Listen, but then see, the original record is not before us. What was? You have to call for record in this case. Huh?
Lordship.
In this case, Mr. S. Islam Nana Counsel for the
P.
petition.
Rahman.
Huh?
P. Rahman.
P. Rahman Nana Counsel for the petitioner. Issue notice written over 3 weeks. Let the original records be called for. List a matter of 3 weeks. We'll see, because in the investigation we'll find out.
Lordship.
Just like have you seen Mr. Sigdar's case? No,
Lordship,
at least
in 11
12 and 13 also record has not been called, have not been called.
Then 11 and
12, 13.
11, 12 and
13.
13. Okay. Same order.
And proceeding may be stayed, your lordship.
Records are called for what the
Lordship.
tribunal will do with the record.
Lordship.
The tribunal will proceed against you on the
Lordship.
on a Xerox copy or what?
Sometime it may happen,
Huh?
your lordship. Sometime it happen.
What sometimes it happens. It doesn't happen. So item number 1, notice, then item number 11,
4.
4 also.
LCR is there.
Item number 4 also. Mokibur Rahman is with 4. Then answer is here. Let us see Mokibur Rahman. In Mokibur Rahman, we have called for the record. In Mokibur Rahman, what is your case? You also transfer from
Lordship, Jorhat to Morigaon.
Jorhat to Morigaon.
Morigaon.
So you are a Morigaon. You are a permanent resident of Morigaon.
Morigaon.
Let us see what does the record say. The matter is still pending.
Pending in. In this case, petition also suffering from some cardiological problem.
Permanent resident of which place? You are permanent resident of where? Which place? Mokibur.
Village Saruk Taka Baha Mazarbori under Mikirbita PS in the
Okay.
district of Morigaon.
Okay.
Lordship.
The matter is still pending
Lordship pending.
before the Jorhat.
Jorhat.
Okay. Now, what order was passed in this case? Any order was passed? No.
No, no order. Only record has been called. Only state the proceed.
देखो हार निष्ठा
P. Rahman.
P. Rahman Lana Council for the petitioner. और सबका नाम लिखना. The records have been received. It is a plea. In this petition, the petition is pled for transfer of the proceeding from Foreigners Tribunal
Jorhat.
Foreigners Tribunal Jorhat to any other competent tribunal located in Morigaon.
Morigaon.
There is only one Morigaon. Only one in Morigaon. How many foreigners tribunal? Morigaon?
More than
5 or 6 years.
Five. Okay. Community where under whose jurisdiction the petitioner is ordinary resident of. It has been submitted that the petitioner is a permanent resident of village Saru Chokabha, Mazarbori,
Under Mikir Vita.
under Mikir Beta police station in district Morigaon. It is a case, it is his case that he had, that in the year 2004, he had gone to Nazira for work and had stayed there in a rented place along with other co-laborers on being accommodated by his contractor. While he was residing temporarily at Nazira for his work, as mentioned above, there was some inquiry made against him as his citizenship was suspected. Accordingly, he gave his statement to the effect that he is a permanent resident of Morigaon, however, had been staying there for earning his livelihood. Unfortunately, the authorities proceeded against him before the Foreigners Tribunal Morigaon in Jorhat, where he was under whose jurisdiction he was earlier working. Are you still in Nazira or you are in now? You have left Nazira now.
Lordship.
Are you still working in Nazira or you have left? Where are you?
Only left after 2 or 3 months.
Okay. It has been submitted that the petitioner has left his work in Nazira and now is permanently residing in his permanent residence in Morigaon. And as such, he has submitted that the proceeding which have been initiated before the Foreigners Tribunal at Jorhat may be transferred to the competent Foreigners Tribunal located in Morigaon. Petitioner submits that being brought up in Morigaon district, in village Mazarbari in Morigaon district, he had all the records about his father and parents, records which are issued by the local and district authorities of Morigaon. Further, all the other witnesses who would support his claim that he is an Indian are all based in and around Morigaon. And as such, it will be practically difficult, it will be of much practical difficulty for him to travel to Jorhat to contest the claim, before the tribunal, and it will be more convenient and also give him more effective right to represent if he is allowed to appear before the competent Foreigners Tribunal Morigaon. That's all. And any other yes?
Lordship. 5 also.
Item number
5.
5 LCR Sohara wali hai.
From Jorhat to Morigaon. Permanent resident of village Pakoria, PS Mayong. Same fact, your lordship. 61 years old.
Pakuria, your permanent resident of Pakuria.
Lordship,
P.S. Mayang, Morigaon.
Mori.
And Mr. Lanagan. Same, he's a permanent resident, he's a permanent resident of Pakuria village. Pakuria village under Mayang police station in district Morigaon. And he had come to which district? Naziria?
Morigaon.
No, from there to where? You had gone to for work?
Nazira.
Nazira, same.
Same year.
Same brick.
Same brick.
Same brick field also.
Lordship.
Huh? Brick field for work. Same contractor? No, different.
Brick field.
Brick field.
Brick field.
Okay. And the FTs were in Jorhat.
Jorhat.
Okay. Same. Then item number 5.
9 year lordship. LCR.
9.
LCR is there.
In 9, what is the case? You are the permanent resident of who?
Permanent resident of Haliha Mari Habi under Mayang PS.
Mayang P.
Morigaon.
And he had gone to Nazira for what?
More sorry. It is a embankment to construct.
In Brickfield, your lordship. In 2004. You went there in 2004. As my instruction is there, lordship.
He had gone to Nazira for construction of embankment in near the embankment at Gaurisagar, as well as for the walk in a brick field. He is otherwise a permanent resident of Morigaon. Same, huh? Document, witnesses. Okay. Documents and witnesses are all located in Morigaon. Then, any other?
Lordship 10.
10 LCR.
LCR is there.
Sharafat Ali,
Sarafat Ali.
a permanent resident of
Haliha Mari Habi PS Mayang.
Mayang. He is a otherwise permanent resident of Morigaon. And I said, he may be, I don't know. And you went where? You went
In
to?
2004, along with the Amsar Ali.
Okay.
Same
Ground
petition.
floor, huh? Same.
Both happened.
Okay.
Lordship,
Yes, sir.
in earlier occasion, the coordinate bench of this honorable court has rejected the transfer petition on the ground that the tribunal is not a court. Or in Mainul Haq case, you are also already sorry for.
Okay.
And Lordship, if you lordship permit, then I'll go on legal point here.
You give us, we are hearing for that only. We want to hear you.
Lordship, in recently, your lordship, res judicata judgment, your lordship, has already decided that in line of the Honorable Supreme Court judgment in Abdul Quddus, that the tribunal is a quasi judicial and its decision is final and binding. That it come under section 3 of CPC, your lordship. The Finance Tribunal is subordinate to High Court, your lordship. Therefore, the section 24 is applicable, your lordship. But in earlier occasion, the coordinate bench has rejected the prayer of transfer on the ground that CPC is not applicable. But in Abdul Quddus, the Honorable Supreme Court has said that, held that the decision of the tribunal is final and binding, and hence the CPC is applicable as per the res judicata judgment also, lordship. Lordship, the petitioners are poorest of the society, your lordship. For survival, they went here and there. They go here and there and came back. Suddenly, then received the notice from other districts, and it is there for them. It is not convenient for appear before travel before the tribunal after traveling such long distance, both physically and monetary, your lordship. On the other hand, the burden to prove his case on the petitioner or the proceeding, your lordship. State just referred the matter and silently wait that what tribunal has been doing or not doing. Lordship, therefore, the convenience, balance of convenience has to be looked into, your lordship. In judgment, your lordship, I'll refer you judgment. Honorable Supreme Court, including the court, paragraph 14, your lordship. May I read, your lordship? Although the discretionary power of transfer of cases can be imprisoned within a state jacket of any cast iron formula unanimously applicable to all situations, it can be gainsaid that the power to transfer a case must be exercised with due care, caution, and circumspection. Reading section 24 and 25 of the code together and keeping in view various judicial pronouncements, certain broad proposition has to what may constitute a ground for transfer have been laid down by courts. Their balance of convenience or inconvenience to plaintiff or defendant or witnesses, convenience or inconvenience of a particular place of trial having regard to the nature of evidence on the points involved in the suit issued raised by the party. Reasonable apprehension in the mind of the litigant that he might not get justice in the court in which the suit is pending, your lordship. Lordship, you are aware that state never examined any witnesses in the tribunal. Only the proceeding has examined witnesses. His parents, age-old parents, grandparents, paternal uncles, and Gabura, school teachers. And if he or she exhibits land documents, he has to examine the Lat Mandal or the circle officer. Therefore, the convenience, balance of convenience should be looked into in favor of the procedure. That is my submission.
You are Mr. P. Raman. P. Raman submits that petitioner belongs to a poor section of the society who has to go around looking for employment opportunities, and as such, mainly because he was located at a time of investigation at Nazira, put him into serious inconvenience if he has to attend a proceeding in Jorhat, in other words, all his documents and the witnesses who would support his case Indian are all resident are located in Morigaon district. The law, the section 9 of the Foreigners Act 1955, however, casts a onerous burden on a proceeding to discharge his burden that he is not a foreigner but an Indian, and if a proceeding is made to travel far distances and examine local witnesses along with him, a serious inconvenience would be caused, and as such, it will be interest of justice and also convenient that he faces the proceeding in his own district in Morigaon and not in Jorhat. In this connection, Mr. Sankar relied on a decision of the Honorable Supreme Court in Kolvinda. They have been submitted that the Honorable Supreme Court in Abdul Quddus has held that the proceeding before a forest tribunal is a judicial proceeding, and as such, and the principle of res judicata will be applicable. If that is so, there is no reason why the principles laid down in the CPC for transfer of petition cannot be allowed if grounds exist for doing so. That's all. Anything else you want? Okay. Next.
Hello, Black.
Yes.
My item is 8, my lord.
8 LCR is there.
Yes, LCR is there.
Lord, before my learned friend starts, my lord, my case is this, my lord, the record is not called for. Item number 6. So
Then we'll
record-
call for the record.
Call for the record. my
Yes, or Mr. Sheikh Lana Council for the
Six.
call for the record.
6.
Call for the LCR. Yes, item number 6. Yes.
Item 7.
7 also, huh? Okay.
Record
Also,
may be-
Mr. Suleiman, Lana
Yes.
Council, call for the records. In FT case number so and so. Naam likhna. Then, yes. Yours is item number?
8, my lord. In this case, the case is pending before the Juhar. And
You are a permanent resident of?
in South Salmana, my lord.
Where is it? Where have you stated?
Paragraph 2, my lord.
Present petitioner is a permanent resident of South Salmara. However, he had gone for looking for employment opportunity in other district. And where he was, and he had gone to, and he had proceeded to where? Where in Jorhat?
It's why there's one house of Bipin Dora at village. Pulong.
And he had gone, he had,
Pulong Sagia in
and he
Gauri
was
Sagar.
staying in one house of one,
One Bipin Dora.
as a tenant in the house of
Village.
Bipin Deora.
Yes, Bipin Dora.
For what?
Or village. I have Delhi just
Okay.
mentioned.
The Bipin Deora of which village?
Or village. Full Panis Figa.
Full Figa district?
PS Shivsagar in the district of
Yes, Shivsagar, district Shivsagar, for as a daily wage earner.
Yes.
Where he was, an inquiry was made against him on suspicion of being a foreigner. He, however, informed the inquiring authority that he is otherwise a permanent resident of village of
Kokila Boiler.
Kokila,
Kokila Boiler Part 2.
Kokila Boiler Park,
Boiler Part 2.
Part 2,
You
PS
Hazirhat. PS Suksar.
Suksor,
In the district of Salmara.
in the center of Dharmara. However, the authorities proceeded against him before the FT.
Zohat.
So it has been submitted all the documents to show that he is an Indian are issued by the local and district administration of Morigaon.
South Salmana.
South Saramana,
Mankasa district. Earlier it is a Dhubri.
Mankasa district,
And document, all documents issued by the then Dhubri district.
and all the documents which the petitioner seeks to rely are also issued by the local administration of Deed and Dhubri district, where Deed and Dhubri district, of which the petitioner is now the president, Dhubri district, Dhubri district,
Now in South Salmana.
now Dhubri district, Dhubri district, out of which the new district of South Salmara Mankasar has been created. And accordingly, it has been submitted that though the petitioner has filed all the relevant documents before the
Tribunals.
tribunal in
Jorhat.
Jorhat, in order to prove these documents, he would be required to adduce evidence by examining witnesses, and it will be highly inconvenient if he is required to produce all the witnesses who are otherwise located in South Salmara,
600 kilometers away.
which is about 600 kilometers away from the tribunal in Jorhat. And as such, the prayer has been made for transfer of proceeding from Jorhat to any other competent foreign family located in Hatsingmari. That's all.
Yes, my lord, in similar case, one person from my locality, my lord.
It has been submitted on Mr. J. Ahmed that in a similar case, this court had allowed the transfer of proceeding to the foreigners tribunal. Foreign tribunal, where the proceeding was a permanent resident of. In his correction, the petition has referred to the decision of this court in Asadul Islam.
Yes.
That's all?
Same locality. I am list of the same locality. my lord. Now, my lord, and the soluble.
This is submit that he is also the same in the same locality as the said Asadul Islam,
Yes.
petitioner in WPC number 63644 of 2018, and I said he may be granted a similar benefit. Yes, then, yeah, that's all?
There, my lord, and one submission, my lord. The in soluble Islam is rendered by this noble court. And that judgment, that order was not placed.
In,
That order was not
it has been submitted by Mr. Mr. Ahmed that in the decision relied on by the state government in
WBC now. 2780 application. Soluble Islam.
in Sariful Islam, WPC number 2780/2018, which was decided on
2019.
and 7/6/2019, the earlier decision of this court, including this court in rendered in Asauddin Islam, which was decided on 17/7/2018, was not brought to the notice of the court, and as such, the same the said subsequent decision may not be applicable, may not have any binding precedence.
And moreover, the Honorable Supreme Court decisions is also
More so
expertly covered.
More so in view of the decision of the Honorable Supreme Court in Moinal Hawk, decided in decided in so and so, huh?
It
SLP.
is expertly covered.
Huh? Number?
Yes.
Yeah, Ahmed. That's all. Any other? Anyone else?
And my lord,
Yes?
and since the tribunal has followed adopted the procedure of the CBC procedure, my lord, and as per section 3 of the citizenship order, the tribunal has also power to recall everything as per the power of conferred in the CBC, my lord. So definitely the section 24 is to be applied, and it yes maybe.
It is now settled, it is now acknowledged by the state also that tribunal, though tribunal is a jurisdictional body which exercises power following the principle laid down in CPC, there is no reason why the principles contained in section 24 of the CPC should not be applicable to the tribunal. That's all. Anything else? Okay, thank you. Yes. Last one. Any other matter which have been left out? Mujibur Rahman will issue notice. Will issue notice. You call for the record. Yes, sir, for transfer.
Yes, then.
This for transfer.
Yes, transfer from Jorhat to Vilashiva.
So what do we want to see the record, original record? How Mr.
Till that.
Mr. Mahmood issue notice of concern. Let the original let the records of the FTG 6420 be called for.
Till then, I may not be disturbed.
Huh?
Till receipt of CR, I may not be disturbed.
What disturbed?
Because police may.
Nothing will happen. What disturbed?
No, it will happen, my lord. It will happen. Police. So some protection, my lord, that necessary.
Okay. In the meantime, the petitioner may not be subjected to any coercive action in connection with the aforesaid FT case number so and so.
Obliged.
With the leave of the court, my lord.
Yes, sir.
With regard to the additional hearing list.
We are thinking.
With regard to date reference.
Yes. We are thinking of taking it up.
Today, my lord.
Whatever is convenient or.
A learned senior colleague of mine, Ziaul Kamar, and myself also there has been a matter in the trial court wherein it has always been fixed in.
Second half.
Personal problem.
No, we understand. That is what we are.
Some
What we'll do is that from next week, we'll take up this first debt reference matter hearing. Huh? Then we'll take up.
Well, next week again, probably he will be also out on Monday and Tuesday, my lord. So will be I, my lord. So can it have a firm date, my lord, so that we can come prepared to address this honorable court? Because it's a date reference, my lord.
Correct. When do you want, tell her?
Say on 18, my lord.
18.
Yes.
18 is Friday.
Yes.
Don't make it on Friday, Mr.
Okay, then, my lord.
You are a lawyer, you know what is
Yes.
what is the significance of Friday?
Then 17, my lord.
Huh? 17.
Actually, 21 will be most convenient if it's not
Don't delay
inconvenient.
too much, because this, we cannot, because these are dead reference. This fellow, poor
No,
fellow
my lord,
is
we
there.
can prepare out a fixed date, my lord. We'll address it. On the day, we'll finish it, my lord. 21, my lord.
No 21, before that. Next
17?
week, next week. Any day next week.
17.
Take it. Then my lord on 17, then on 16, 17 will be more better. 16 or 16, my lord, let's be. 16, my lord.
16, there is a single bench matters also. No? Monday and Wednesday, there's some single.
That's why if we go by a firm date, my lord, I'll definitely.
No,
back
next
up.
week, next week.
Yes, my lord. 21, my lord.
Next week, 21 also we cannot, because it's a Monday.
Tuesday, then.
No, sorry, next week.
Okay.
Any day next week.
As your lordship will suggest, my lord, we'll go by it.
Tuesday. You may have
Date, my
15,
lord,
you may have 15 or 17. I don't know this. 15. 15? 15 you will come
15, I'll be
prepared?
out of station, my lord. So 17, my lord.
17. 17?
Yes, ma'am.
17? Okay.
Item number 1 to 6, ma'am.
1 to 6. Huh?
Yes.
So,
No, there are two, my lord. We'll prepare.
Two date reference are there.
very well.
No, we'll have to address one first. Then.
Yes,
It will
at
not
least
be
we'll
possible.
Huh? But others, what about other counsel? See, that reference, Mr. Jamar, you are the amicus.
Yes, my lord.
And Mr. Bhuya, you are for the
Appellant.
For 1 to 4, my lord, I am for the informant.
informant.
And 5 and 6 for the appellant, my lord, convict, man.
Or you also for the?
Convict for 5 and 6.
No, in item number 1.
1, my lord, for the informant.
For the informant.
Yeah.
And who is the appellant?
Appellant is one amicus curiae one.
Munir.
Oh.
Probably Munir. I can
Susmita
inform you.
Kanungo. Susmita Kanungo.
Kanungo.
Where is
I'm
Mrs.
not aware.
Where is Miss Susmita Kanungo? If suddenly she doesn't appear, then all
Then
of you.
everything, whole thing will, because he will start.
She has to start. Huh?
I think Munir is also there, my lord.
For one of the accused person.
One is
And Miss Susmita.
And PK Munir, what about PK
I
Munir?
can inform Munir, my lord.
What about Susmita?
I'm not aware, my lord.
Susmita Kanungo, inform her.
I know one.
For you know it is fixed, not to be, that she must come. Huh? Abhi phone karo to. Otherwise, we will arrange another amicus then. We don't want, because all the senior will be all
Yes,
tied up. Huh? Because you will unfix other cases. No?
That's why I.
That is why
date, my lord,
we
so
want that everybody should be present on that day.
Absolutely,
Yes.
Otherwise, it will make again create problem.
No problem.
Susmita Kanungo, just give a call, we'll see. And also PK Munir,
PK Munir, I take the responsibility.
please
I'll
tell
inform
him that
I'll address him. But so for this ladies concern, my lord, I have got no acquaintance.
We can start to do this.
Junior senior.
So if we start this date reference 1, 10, this one,
My obviously senior power to Smita Sen. Okay.
Susmita Kanungo.
We can fix on 21st. Because next week we start this.
She's coming? Well, she is on the way, my lord, probably, if we can spare 2 minutes. We'll address the first, well, I'm amicus in both the cases, my lord, but I'll prepare one at a go, my lord. Because somebody's life is at.
Obviously.
government.
What we can is that, okay, Susmita is coming now.
Yes, my lord.
Okay.
She has got the connection.
Oh, she has come. Where she has reached? In the court only. Okay, then we can wait for a few seconds. Then we'll start this one.
Which is the yes, sir. It will like telecast. It will UPS box. Yeah, like it. It had to be like us.
He's there, man.
Fine. Yes, sir.
Extremely sorry, my lord.
No.
Date has been fixed on 17, so you have to be present here. That is the court. Yes, she is agreeing, madam.
17.
So you are coming on 17?
Lordship.
Because these are dead reference, we don't want to delay it.
Lordship.
The Learned Senior Council, they are all ready. Mr. Bhuya also ready. So
PP is also ready, madam.
PP. PP, you are ready also on 7? 7, very good.
Ever ready, madam.
Ready. Ever ready. Good. So,
This 7 and 8 are also not that reference.
correct, but let us do one by one.
One by one.
Let us not rush.
Morning.
Sorry?
Item number 8 was mentioned in the morning.
Oh, 8 was mentioned in the morning by whom?
By
Hey,
Mr.
Jasminuddin Burmiya. What is this? He said that he may not be able or something like that. It is 7. He's along with 7.
Perhaps tentatively it was fixed on 17/11.
No, we'll say that we'll see because so there is no issue. Because first of all, there are 3. First, number 1, then number 5,
Yes,
then number 7.
my lord.
So one will take it up on 17, definitely.
I
So
think,
it may take some time, I don't know.
I still remember your lordship golden word. Let us first start, then only it will end.
Yes, yes.
Your lordship always open quotes.
No, I don't know how long, Mr. Zaman, you must be knowing some idea how long it's likely to take this case.
I don't think it will take much of a time, but
I
if
see.
lordship, I'll
Yes,
point out the
19
solid state of affairs of the investigation and the
I don't know.
court's judgments also, my lord.
Okay, so we have to go through those records itself. Therefore, the whole day likely to take.
Likely.
Likely. Okay, then, because we don't want to rush.
No, don't rush.
Prosecution witnesses. my lord.
Sorry?
In item number 1, 19 prosecution.
So we have to go through each and every statement.
And
Huh?
3 DWs
The DW, cross examination, all those we have to go through.
and 164 statements are
Okay.
also there.
So first, definitely without any fail, we take on 17.
My lord,
Okay. Okay.
that's a fix.
Okay, thank you.
Will be here, my lord.
Thank you.
Much over.
Achha, second half is Mr. Pine. So what do you say, Mr. Pine? Tell us.
Can be my part be heard in some other case? Tomorrow, no problem.
This today's matter?
Yes.
Okay, not today.
Not-
Okay, very well. When can you do then?
No
Today
problem.
is what day?
Any day, my lord.
Today is Today is 10th. Tell us any date. Tell us. You tell us. Monday, 14th? Monday?
Yes.
So this Monday, okay. Likho. Mr. Pine, in response, Mr. Pine has submitted the submissions advanced by Mr. So-and-so. And however, he will continue his submission on 14th.
My lord, only those whose matters has not been disposed of.
Yes.
Yes. in
No,
that-
and also that those two which have been disposed of, Mr. Sigdar also
case of
disposed of.
There's case, my lord.
Those two cases where records are before us. Those cases where records are, we are not
My lord,
touching.
Then that matter may be taken in a separate, different date, because my lord, there I have to prepare separate.
Which one?
In the merit, on merit matter.
Which one?
Mr. Sigdar's case.
But then Sigdasi is all ex-parte matter. Mr. Pine, those are ex-parte matter.
He has raised some legal issues there in that case, my lord.
No.
I have to, he has.
But those
raised-
are the ex-parte matter. That's what.
No, my lord, he has raised, because if it is only ex-parte, my lord, there was no case. But he has raised some issues, my lord, regarding investigation and etc. So I have to rebut those.
So to do that. But then these are the same thing in foreigners tribunal. That is what is there, not, except for investigation, reference, and proceeding.
No, that is true, my lord. So if
And you are a veteran. But you know more than us. Mr. Pine, you have been handling this FT matter since, I think, at least I can say that he knows better than me also.
that is true.
So I don't think it will be a very difficult thing because he has not raised too many, except the question of law, which have been agitated from time to time.
Okay,
How?
let me see if I could.
We'll give you, no, we are not, yes, we'll give you time, but you can at least start.
Let the board, only matters. be listed.
Also, whatever today are good, today will be listed on 14, we'll accommodate, we'll give you more time if you want, there is no problem.
Yeah.
And in the second half, they all hearing matter of what? FT? Okay. And so in second half, we thought learned PP, we see hearing matters. First, we want to give preference to the criminal matters, criminal appeal, because there are two sets of appeal, FT appeal and this criminal appeals, jail appeals and criminal appeals. So we like to second half. Are you ready with any matter? No.
No, I prepared only item number 1 for that reference because.
Yeah, item number 1 has been, yes, now been adjourned to 7 days.
From the paper books, if somebody.
Item number 1, ready, lordship.
Huh?
Item number 1, hearing matter, lordship.
Item number 1 of
I'm ready for. FT.
Subir Mandal.
No, sir, no lordship, Rehana Bibi.
Huh?
Rehana Bibi.
Hey, foreigners tribunal, wait. And there are people waiting in jail. Some are to be hung. You are at home. Why are you worried? Huh? You are not in detention camp even. But these are, they have been sentenced to death. They are, 4 or 5 years they're in jail. We want to give preference to that. That is why we want to